You suffered significant harm and injury as a result of a doctor's carelessness. In today's video, I want to share with you the two things that you can do that will help improve the value of your injuries when it comes time to negotiate your particular case. Would you like to know what they are? Come join me for a walk through the neighborhood as I share with you exactly what they are. Hi, I'm Gerry Oginski, a New York medical malpractice and personal injury attorney. Now, during the course of your lawsuit, you may think that your case is clear-cut. You may think that the value of your injuries are clear-cut. But I want to share something with you. The defense doesn't see it that way. They never do. They will fight us tooth and nail on liability, on establishing that their doctor and the hospital staff were careless. And even if we are successful in showing to them that their doctor and hospital staff deviated from the standard of care, and caused you injury, they will always fight us on the issue of the extent of your damages. How badly were you hurt? What disabilities do you have? What activities are you no longer able to do today? They will always fight us on that issue. So what is the best way that you can help your attorney maximize the value of your injuries as you go through your lawsuit? And I'm not talking about exaggerating. I'm not talking about saying anything that's untrue. So if we put that aside, what is it that you could possibly do? What are the two easiest ways that you could possibly help your attorney maximize the value of your injuries? The first is to communicate with your attorney on a regular basis. This is the simplest way to improve the value of your case. You need to continuously update your attorney on your condition every few months. Absolutely, that is a requirement in my eyes. Why is that? Because oftentimes your attorney is doing things on your case that goes on behind the scenes, and he does not have an opportunity to talk to you to see how you are feeling. Are you improving? Are you getting treatment? Do you need ongoing therapy? Do you need surgery to correct any problems? Your attorney needs to hear from you on a regular basis to assess your current medical condition, or at least to assess your condition and to how you are feeling. How are you getting along? Are you able to return to work? How are you dealing with family life? How are you dealing with your day-to-day activities? Are you incapacitated? Do you have pain on an everyday basis? Are you taking pain medication? Is it narcotic pain medication, or is it over-the-counter like Tylenol and Motrin or ibuprofen? Your attorney has to know all this, and if he doesn't hear from you on a regular basis about how you are feeling, then there is no way for your attorney to know exactly what progress, if any, you are making. It is critically important that if you are seeing any new doctors, and this comes to the second point I want to make, if you are seeing any new doctors for any of the conditions you suffered as a result of the improper care and treatment, it is vitally important that you reach out to your attorney or your attorney's secretary and let him or her know that you are treating with other doctors. Why is that important? It's important because your attorney has to obtain copies of those records. Your attorney then has to take copies and share them with the defense attorneys. Your attorney has to provide permission slips to the defense lawyers so they can go ahead and get your treating medical records on their own, because they don't necessarily trust us to give them accurate and true copies of your treating doctors. That's critically important. If you were to wait till the last minute, let's say you go an entire year, and now you've seen many doctors since you had initially spoken to your attorney, and now your attorney starts to have settlement negotiations with the defense, he is going based upon the fact that he is only aware of doctors that you treated with up until the time that you last spoke to him. Why? Because you never updated him about any treatment you were receiving. So now any settlement discussions he's going to have with the defense is going to be limited to those doctors you had seen in the past. He may not know about any of your current treating doctors. And because of that, that is going to destroy your settlement discussions. Why? Because now your attorney is at a significant disadvantage. The defense lawyers are at a significant disadvantage. They won't have, and they don't have, all the necessary details of your ongoing medical care and treatment at the time that these premature discussions are happening. And that is why it is critically important that as your case progresses, no matter who you see, it is vitally important that you update your attorney and your attorney's office about these new doctors, about the complaints that you're having, to allow them the opportunity to get those records over to the defense, to give the defense an opportunity to read them, to analyze them, and now evaluate whether your injuries truly are as bad as you claim them to be. If your attorney were to engage in settlement negotiations without having your latest and updated medical records, now it would be doing you a disservice. It would be doing your entire case a disservice. And the defense would not be able to go back to their principals to show them, look, Mr. Oginski's client has had all this treatment and now needs all this additional treatment, and all of these ongoing procedures are going to be needed and necessary. And they're going to argue, hey, you never told us about that. We didn't know about that. How can we negotiate in good faith if you didn't provide us with any of this information? And that's why failing to tell your attorney about your ongoing treating doctors is going to be a huge disservice to you, as well as not updating your attorney on a regular basis about your ongoing issues and problems. Because now, if you were to go ahead and do that on a regular, frequent basis, your attorney is in a much better position to have a factual basis for a good faith discussion with the defense. So now he can say, look, my client is still undergoing care and treatment with the following doctors. Here are his complaints. Here are the problems he has on an everyday basis. We just sent you over those records. Take a look at them, and after you've had a chance to go through them and analyze them, we invite you to call us for settlement discussions. That is a much better strategy to use, and much better in order to maximize the value of your injuries in a case involving medical malpractice, an accident case, and those types of things are what you need to think about as you decide whether or not to go forward with a case of your own in the state of New York. You know, I realize you're watching this video because you likely have questions or concerns about your own matter. Well, if your matter did happen in New York, but you have not yet started a lawsuit and are thinking of doing so and still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a wonderful day.